Law Matters. Of course it does. Hi, I'm Debbie Moraes, your host and moderator. This program has been created to educate, inform, and help you with law matters because the law matters. Understand the law better, and you're in a better position to decide how to protect yourself, your family, and your business. We continue to provide the information and resources that may help you decide whether or not you need or want to contact a lawyer. In fact, we may help you determine that you may handle some issues yourself. If you do need outside counsel, you'll be better prepared, and as a result, so will the professional you select. Of course, our goal is to help you save time, money, and achieve the best possible results always. We welcome and thank once again Attorney David Bazar from the Bazar and Associates law firm in East Providence. They continue to provide the legal information, advice, and counsel on the various segments and issues that we tackle each time. So today, the unauthorized practice of law. It happens. So what is it, who does it, who wants it, and what you should watch out for? Imagine, actually, Rhode Island and Massachusetts are two states that have hit the book, so to speak, when it comes to this particular offense, and it means things beyond suspended and disbarred lawyers. So this is quite a topic. And if we have time, we'll also cover the unbundling of legal services, which is an interesting topic too. That's a little bit of a tease. We'll see if we get there. So David,
yes.
What is this UPL?
UPL, the unauthorized practice of law. In order to practice law in a state, you have to be a member of the bar of that state. So to do that, we talked about that last time, I think, about going to law school, taking the bar exam, practicing law based upon obtaining a license to practice law. So if you don't go to law school, you don't take the bar, you don't pass the bar, and you still practice law, it's illegal. It's actually a crime to practice law in a state without being authorized by the state to practice law.
So if you took the bar in the state that you live in, does that mean you can't ever practice law in other states, or do you have to take bar exams for each state, and why?
So, as we mentioned before, you can now actually take, in some states, a bar exam that is accepted in more than one state. And when I was taking the bar, you couldn't do that. You had to take the bar in each state. But in any event, you still have to be licensed in each state that you want to practice in. So if you're a member of the bar of the state of Rhode Island and you want to practice in Massachusetts, you have to take the exam in Massachusetts, or in some instances, if you've been practicing law for a certain period of time, usually 5 years or more, you're able to waive into the bar, which is you take a couple of exams, or not the whole set of exams, but some of it, or whatever it is that that state may require for you to be licensed in the state. But the bottom line is you have to be licensed in every state or court that you want to practice in, because remember, there are federal courts too.
So is that an issue about each state having an opportunity to give you a little grief, charge you a little extra money, or is it just that they want you to know that the laws vary from state to state? It's
because they want to make sure that you're competent to practice law in the court that you want to practice law in. And the laws do vary from state to state. The practice of law varies from state to state. And it's really about protecting the public. It's not about giving you grief or collecting more money or any of those kinds of things. It's about making sure that the public can be assured that if they go to a lawyer who's licensed by the state, that they have taken the exams and done all of the things to show that they're competent to practice law.
And if you are a lawyer in a particular state, it means that you are entitled to do all things that other lawyers do. Is it different from perhaps you having complete you have complete control over one state, but maybe only partial in another state? Are there those kinds of parameters to work within, or no?
Not that I'm aware of.
Okay.
And again, remember, the states or the courts that you want to practice in, whether it's federal or state, they want lawyers who are competent for the public, but for their own purposes, they regulate and discipline lawyers. So if anyone could just practice law without being a member of the bar that the court is attached to, how are they going to regulate discipline for that person practicing law. So if they're violating the attorney code of ethics, if they're not following court procedures, there's no ability for the court to have control over that person or discipline that person. So it's really about the court controlling, or the state controlling, or the federal government controlling how law is practiced within its courtrooms.
So what do they mean when they talk about, or as I read about, practice law for a limited purpose or on a restricted basis? What kinds of examples come to mind about that?
That sounds to me like unbundling of legal services.
Does it?
Yeah.
It wasn't really presented in that context, but okay.
So this is about representation of clients. And the unbundling of legal services is really designed to meet the untapped, unmet market for people who have legal needs that can't afford to hire an attorney to represent them for every aspect of a case that they need. And it used to be, if you enter your appearance for somebody in a case, you can't get out of that case as a lawyer without permission from the court to withdraw. So, for instance, I'll take a family court case. If somebody just wanted help in their family court case with an order for temporary allowances, which is, what am I going to do with custody and visitation and child support and maintaining the bills and all of that before the divorce rolls around, if you enter as an attorney to represent someone for that, you've entered for the entire case. So you would have to charge that person for the entire case. Limited scope representation allows you to enter for the limited purpose of one aspect. So it could be just for that temporary allowances motion, or it could be to enter a final judgment, or for a hearing on some merits. But in any event, you're able to get in the case and out of the case without having to get court permission to get out, because it's a limited scope representation. Therefore, you can charge less. And it gives people the ability to hire an attorney to do some aspect of a case for them or help them with some aspect of the case. And there is probably, I've been told, a $500 million unmet legal need for the market that's out there that lawyers could help people with and make some money, and the people can be served to some degree rather than having their legal needs totally unmet and having to be pro se on every aspect of their case.
That's a good point. So back to the thought about it, what an unauthorized practice of law is. There are things that you as a lawyer, an attorney at law, bona fide as you are, you can do, but a paraprofessional can't do. What are the limitations of a paraprofessional, and how do you define those careers or those terms?
So a paraprofessional or non-attorney person, assistant, can help an attorney prepare a case, can help an attorney work on a case, can do a lot of things, but what they can't do is give legal advice, they can't go to court, and they can't really operate without the supervision of an attorney.
Would that be a paralegal? Is that a...
Usually.
That's usually what it is.
Usually it's a paralegal.
If you're a clerk, what status is that? Is that considered a paraprofessional?
Yeah, it's
as well?
another name, really, to me. But maybe the difference is, oftentimes we talked about law clerks as being someone who might be in law school.
In law school.
And needs to get some experience, so they clerk with you. In other words, they work for an attorney, doing some things, many times this thing similar to what a paralegal might do, but they're coming for the experience as much as for the money.
So would a law firm be able to charge the same amount for the work that a full-blown, fully credentialed attorney at law would do versus, or what a paralegal or whatever else, someone else might do?
Usually there's a different fee charged to a client for work done by a paralegal as opposed to work done by an attorney. Oftentimes, that's how legal costs can be kept down, because, as I said, there's a lot of things the paralegal can do to assist the attorney. Again, they can assist, but they can't give the legal advice. So I'll give you an example. You have a lawsuit for, say, an auto accident, and interrogatories have to be prepared or answered. So what interrogatories are? A written question sent to you for your client to answer. So a paralegal can certainly go back and forth with the questions and answers to get information from the client as to what the answers are. But they can't give the client legal advice as to how to answer a question. The attorney has to do that. And what we do is they might make the initial meeting with the client or initial inquiry with the client to get the information and start working the answers up. But the attorney has to meet with the client to go through the answers and advise the client on how they have to correctly and properly answer the question and make sure that it's sufficiently answered and complete and responsive to the question. So an attorney has to do the legal work on it and give the legal advice, but a lot of the time that is required to answer that question can be done at a lower rate for the client than the attorney would charge.
Good for the client to know. So as I read about this and as I hear you describe it, the distinction clearly is legal information versus legal advice. I might read something and quote what that statute is, and I'm not an attorney, but what to do about it or how else it plays out or what it means to that client and how it impacts on their life, that's where you are able to give advice I wouldn't be able to.
I guess in simple terms, that's pretty close.
Lowest common denominator.
Yeah, right.
That works. So what about you who practice law in the state of Rhode Island, for example, but your client also has some issues that are going on in Florida? You aren't likely to practice law daily in Florida. Would you be considered unauthorized to practice law in Florida? And how would that actually play out from your point of view and the client's point of view?
Right. So if someone came to me, and actually it's happened, where they have a case in Florida, what I tell them is you need to hire an attorney who practices in Florida. I can't practice law in Florida. It would be prohibitively expensive for the client to hire me to go to Florida. You can be admitted to a bar for one case in particular on a basis called pro hoc vici, which means that you have some connection to the case and the client has a connection to you, and you have to have a local counsel in that state where you want to do the case. But even though I'm not a member of, say, the Florida bar, I can have a lawyer in Florida petition the court on my behalf to represent someone along with them, because you have to have local counsel, on a case-by-case basis, pro hoc vici. I don't do that, but it can be done.
So you would pretty much say to someone, find a lawyer in
Florida.
I might be able to suggest 3 or 4 who I know of who handle this kind of case,
Right.
but it would be a criminal violation for you to do that if you were to try to?
It would be unethical and criminal.
And that's where I was going to go with that. So it's criminal and unethical, and who polices, monitors that you or somebody else doesn't do these kinds of things, and what's the consequences for those lawyers who do commit these crimes?
An attorney who practices law in a state where he or she isn't licensed can be prosecuted by the Attorney General's office or district attorney or whatever the prosecuting office is in that particular state for violating the law and practicing in a state they're not authorized to practice in. Mm-hmm. That state will then refer the case to the disciplinary council, the Board of Bar Overseers, or the disciplinary council in Rhode Island to say that this person has been convicted of a crime for practicing law in violation of the statutes, and the disciplinary council can then move to suspend that attorney's license.
So apparently, from what I've read, with the state of Rhode Island, for example, within the Supreme Court, there are several, 14 people who are on alert when someone reports this kind of case. So who would be likely to report the case? The client who just found out that that lawyer isn't qualified or credentialed in that state? Would it be another lawyer? Would it be the court itself in the other state? How would that play out?
It could be Any and all of the above.
Okay.
So in Rhode Island, I think you're talking about the committee. That's a committee of the Supreme Court. That's the Unauthorized Practice of Law Committee. And they have people file complaints against other folks who are practicing law without a license, whether they're attorneys from another state or some other practice. And here's the thing, and this is what I was getting at a little bit with the unauthorized practice of law in connection with unbundling of legal services. There are people out there who are not lawyers, who are helping other people fill out divorce papers, for example, or other legal documents that get filed with the court. That is the unauthorized practice of law, because to fill out those papers, you have to give someone legal advice on what is required to go in each section of the form, even if it's just a form.
True?
True.
So what happens if my grandmother needed to have a form filled out? I'm not a lawyer. Am I not authorized and allowed to help her fill out that form?
You could help her fill out the form, for example, if she needs help to say where does her name go, and what. But if you tell her what grounds she should be filing for a divorce under,
so
I think you're giving legal advice.
That's
now, I'm not so sure anyone's going to file a complaint against you for helping your mother fill out a form. But if you go to somebody who charges you to fill out that form, so they're charging for their legal advice, and they're saying, well, you don't want to file under irreconcilable differences. You want to file under behavior that's repugnant to and in violation of the marriage covenant. That's legal advice. And why do I want to file under that? Because you get this, this, and this versus that, that, and that. It's legal advice. It's the unauthorized practice of law. And there are people out there who are doing that. And if somebody has paperwork filled out by them and it's done wrong, they might be the ones to say, hey, they're violating the rules, and I'm going to report them to the Unauthorized Practice of Law Committee through the Supreme Court in Rhode Island. So that's one way that that might happen. And again, that sort of goes hand in hand with the unbundling of legal services, because you could hire an attorney to help you do that, and they might be able to charge you much less to do that. Now, Rhode Island requires attorneys who help someone fill out paperwork, if they actually do the paperwork for them, to sign that they did it, because there's a Rule 11 sanction in Rhode Island for someone who files something that's not correct. That's sanctionable. It's raising issues that shouldn't be raised beyond the scope of what should be done. And the court likes to know who wrote papers, because they like to know who to sanction if they have to sanction someone. So the attorney has to sign that they assisted in or drafted the document.
So there are some interesting consequences that I was reading about, and there's one, the case that represents the two Rhode Island and Massachusetts states with a couple of brothers. But before we finish this, when there are consequences, someone might be fined, might be sanctioned, might be suspended. If that happens in one state, is it more likely that other states are likely to say, if that person was disbarred, suspended in Rhode Island, we don't want him to practice anymore in the state of Massachusetts because Rhode Island, he did something wrong in Rhode Island, and that's a bad reflection?
Yeah, that's possible. And one of the things that happens when you apply for admission to a bar in another state or jurisdiction, they ask you if your license has been suspended or if you've been disbarred in any other state. And the worst thing anyone applying to be a lawyer can do is not give full disclosure on their application. In other words, lie.
Fib, yes.
Yeah, you can't do that. That's the worst thing you could ever do, because first of all, it's a criminal act, because you're filing under perjury rules that it's true. And second of all, if you had something as an indiscretion as a young person, they'll talk to you about that. That's not necessarily going to keep you from being admitted to the bar. But if you lie about it, that's going to be a problem.
Good to know. So there's a very interesting case that made the books. Two brothers, they were licensed only in Massachusetts. They opened up a law office in Providence, and which was run at the time by one of the brothers' then wife. Do you know of this case? I don't know if you do, but anyway. So she was licensed to practice in Rhode Island, but worked only a few hours, and only a small part of the firm did she own, and she didn't have any supervisory authority, and on and on. 7 years later, brothers hire another Rhode Island lawyer. He had no cases of his own, lacked supervisory, whatever. These brothers made all the decision in the firm's cases, and they did all the work and all of this business that you know. There were some consequences there. They finally, even though they were flying under the radar, that's sneaky, that's lying, it's sneaky. They actually were caught up with, which doesn't surprise you. They plead no contest, and what happens? They get barred from maintaining offices. They had something on a website that said, we are licensed to practice in Massachusetts, but they had a wonderful photo of the Providence beautiful skyline, which of course you might think would cover them. No, it didn't. They had terrible consequences for doing this. That's clearly fibbing to the state. Okay. And now what happens? They don't get to practice in Massachusetts. Massachusetts, the one that nabbed them. Rhode Island doesn't want them practicing either.
Okay. So
please weigh in. It was a great story.
So they really wouldn't have had a problem with either the wife running their law office or the other lawyer. But my understanding is they actually went beyond that in what they were doing in the state. They would have been fine if they just stayed within the confines of what they were allowed to do. Because you can be a Massachusetts lawyer as part of a Rhode Island law firm, practice in Massachusetts, and have the Rhode Island lawyer do all of your Rhode Island work.
There's some
That's
reciprocal agreement because of that?
You have lawyers that are in your office that are licensed in the state. They can do the work. That's not the problem. The problem is when you do the work, and you go to court, and you do the depositions, and you do the arbitrations, and you sign the pleadings. That is where the problem lies. And so that was brought to the committee, I guess, the Unauthorized Practice of Law Committee. There was findings and hearings, and then a referral to the Attorney General's office, and a plea out for violating the law, which was then sent to Massachusetts, which put its own suspension in place.
So there's not a chance that they could say, we just weren't aware that we were doing something wrong. They had to know that, correct? Most lawyers would know that they can do this, but not that.
I can't comment on that particular case because I don't know, but in general,
okay, do that. That's
you
fair.
could say that you know what you're allowed to do and what you're not allowed to do. And you know, there can be some question about what's practicing law and giving legal advice that is, you know, based on another state and what you're allowed to do based with your license. That can be a little bit of a gray area. For example, if someone comes in and says, I have a house, I want to do this, this, and this with it, but I have an estate and you're in Rhode Island and you're planning their estate in Rhode Island, but they have a house in Florida. Can you give legal advice on estate planning? I think that probably is okay. Just because they own property in another state, you're not selling the property, you're not doing a closing on the property, you're not telling them, you know, what they have to do, you know, to fill out Florida paperwork, but you're planning an estate for people who live in Rhode Island. I don't see that as a problem. But you can see where it can become a gray area going further and further down the road from there. Same thing with what you can and cannot do, giving legal advice in court things and stuff. But clearly, if you're not licensed to practice in a state, you can't sign pleadings and documents and things that are for that state's court that you don't practice in.
You can't negotiate for them. What else can't you do?
Well, you might be able to negotiate.
So actually, I saw one that said that they couldn't. So how would that play out?
It depends what it is and what advice you're giving. All right, you're doing a business transaction.
Good example.
The business has business in Rhode Island and business in Massachusetts. You're a Massachusetts lawyer. What part of it is Massachusetts law and what part of it's Rhode Island law? What part of the transaction can you consult on and what part can't you? Pretty much, I think, if it's a business transaction and people understand what your role is in the transaction, you can negotiate that deal. Now, I don't think you can give legal advice if it's like strictly a Rhode Island transaction and you're a Mass lawyer. Oh, this is what you have to do, but you can give advice on how a contract can be signed in contract law, at least in general. So it's a gray area.
Do you need to have a waiver or something? Do you need to disclose to your client, here we are in Massachusetts, you're asking me to handle this business transaction, yes, we can do this, the part that's in Rhode Island, I need you to, do you have to say, I need you to know that I'm not licensed to, not that this is the case of you, I need you to know that I'm not licensed to practice in Rhode Island per se, however the same rules apply to us and such. Do you have to have them sign a waiver, or do you have to acknowledge it?
I think there's some discussion that has to be had on it, and certainly depending on the complexity of the agreement and what it is and what's involved in the state you practice in and what's not involved, you might need to bring a lawyer in from the other state, perhaps. You know where it becomes a really interesting issue is for in-house attorneys, attorneys that work for corporations, for example. Where are they licensed to practice? Where's the corporation? Are they at the corporation headquarters? Do they have to be licensed in? And there are rules that apply for in-house counsel that give them some leeway on what they have to do. But that can be an area where it becomes a very interesting subject.
How about when a corporation is multinational, never mind multi-state, and you have an in-house lawyer? Do you also need to have an outside separate counsel in each one of those countries that you're collaborating with?
I'm glad you said outside instead of out-house, but yes. Oftentimes big corporations have their in-house counsel, their general counsel, but they always have lawyers from outside that are licensed to practice wherever they need to have them.
So based on the limited scope representation that you mentioned earlier, how you described how it might help the client. How might it help you? Does it help you while you might be interested in expanding a business because you only have to do some part of it versus all of it might require less time?
Are you asking me how it helps the client
how
or
it
the attorney?
Helps you as a lawyer?
Well, it allows you to represent someone who could not afford to hire you for the entire issue, case, transaction. And so you can still make some fee on the case, and they can still afford to hire you for what they need to hire you for. So it can, add income to your practice.
And I would think if it doesn't take you that long, sometimes I imagine there might be cases you don't really know how long it's going to take you once you get involved with it, but it allows you then to go on to do other business should you need to. And then I imagine it must work the other way, where someone says, I really can't afford you, David, but I need some help. And you start to work with them, and then they realize that they can't do everything else on their own, and then you end up with more business that way when they say, I'm throwing up my hands, David, it's all yours.
That's right. And they might decide that, you know what, for what the cost is, it's more affordable to hire you than not to hire you.
That's a good point too. But you explain these things when you first meet with a client.
Yes.
Are you obliged to tell them that you could be doing this in part rather than in whole?
Well, what we do, because it's part of the fee situation, is we discuss all the possibilities of how you might handle a case.
Good to know. This has been a fact-filled time. Thank you so much for tuning in to The Law Matters. We hope that you'll stay tuned to The Law Matters because it matters to you.